Hello and thank you for joining in on today's training. Heart & Solutions is a proud provider of CE-eligible trainings for our counseling community. This training may be eligible for continuing education credit hours through either the National Board for Certified Counselors, provider number 7376, or the Association of Play Therapy, provider number 21-645. To obtain CE hours for today's training, be sure to follow the steps in the description below to find and take your quiz.
Thank you, everybody, for being here. I am really excited to be able to have Kate Haberman with us this morning. My name is Dr. Colleen Grote. I am the Vice President of Therapy at Heart & Solutions. We are a strength-based agency with offices across the state of Iowa. We provide both therapy and BHIS services. So really excited to have everybody here and joining us for this training today. We will kind of dive in. And for those of you that are not familiar with Kate Haberman is an LISW, MFT, and RPT-S. She has over 20 years of experience working with children and families. Kate is the owner and director of the Center for Foundational and Relational Wellness, which is located in Waverly, Iowa. She has a specialization in trauma and attachment. As I mentioned, Kate is a registered play therapist and a play therapy supervisor. She's a state-approved social work supervisor and is certified in TheraPlay and filial therapy. In 2019, Kate was awarded Play Therapist of the Year by the Iowa Association for Play Therapy. Kate works from an attachment theory, neurosequential development, and family systems basis. She has extensive experience and knowledge in early developmental trauma, parent-child relational dynamics, childhood trauma, and working with the court and foster care system. Kate utilizes her strong communication, attunement, and relational skills to aid clinicians in enhancing their knowledge of development and relational patterns, child-centered based play therapy, sand tray processing, and ways to increase confidence in clinical advocacy and testifying. In practice, Kate specializes in working with children and families who have been affected by trauma and attachment disruption. Kate serves as an expert witness and offers professional training throughout the state. Kate is a foster and adoptive parent and adjunct professor, is married, and has a 13-year-old daughter and 9-year-old twins. So, Kate, we are so excited again to have you here. Kate has a ton of great information, resources, lots of upcoming trainings that I'll talk about at the end of today. And I will make sure that you guys have access to her website as well, which is CFRW, the word Iowa spelled out, .com. I'll make sure that's in the chat as well for you, because she's got some incredible trainings coming up that I will talk more about at the end. Lots of resources and helpful guidebooks and access to things that I want you all to be able to check out. So, Kate, I will let you take it away and teach us more about play therapy in the courts.
Sounds great. Thank you. Good morning, everybody. We're going to talk about the court system this early in the morning. So I'm sure that everybody's thrilled and excited to do that. Often as play therapists, we're often asked to work within the court system in some capacity, whether that's at a family team meeting with an individual DHS worker. Sometimes we're subpoenaed. Sometimes it's privately, so that, parents that we're working with want to subpoena us for a custody hearing. So there's all different ways that as therapists, we're asked to work within the system. And often that's not the most popular, task that many therapists would like to be working with or working on. And I'm really, my goal of this training is to really challenge that for everybody as a therapist, because I feel like it is our ethical responsibility. I'm coming from the social work standpoint, but it's kind of across the board. I do believe it is our ethical responsibility to lean in to working with the courts instead of trying to avoid it, trying to get out of the subpoena, that kind of thing. So as we navigate today's training, I'm really hopeful that all of you will participate in the conversation, that you'll ask the questions that, maybe are the barriers that you have moving forward with working within the system. I understand that some people work for agencies that have sort of agency policies on how to navigate things. And obviously, I can't speak to that. But I also hope that you can consider the information that we talk about today and bring that back to your agency as a way to maybe explore doing things a little bit differently. So, this training that we're going to do has been a full day training and we're condensing it. So there are some things I'm going to move through quickly. However, if that's more information that you would like to have, I will send over my slides with some of the information taken out that is more confidential based so that you do have the ability to sort of navigate it a little bit more closely. You've already seen my bio. However, I do want to stress some of the things that have really motivated me to get into specifically this topic. I was trained in my bachelor's level social work as a child protective services investigator, and I really believe that introduced me to not only the systemic part of things, but it also gave me an opportunity to see a social worker in the role where their involvement in the system was primary. And so really being able to start a case from the beginning when we're talking about children or talking about families, right from the investigation, and then looking at how we are presenting that information within the system, how we have to testify about that information, and then how it kind of the trickle down effect, how that initial interaction within the system can affect everything else that moves forward. Along with that, I do have pretty strong communication skills, and so I believe that that's part of what has motivated me to continue working within the system. Just the ability to explain or lay out or describe situations in a way that's intentional and clear to other people in the system. About 7, 8 years ago, I received several pretty high profile cases. And that's really what pushed me into the expert witness testifying that I've been asked to do throughout the state. It started with cases of my own and then transitioned into other cases. So we will talk about sort of the difference of that too, about, how to testify as sort of a blind witness or an expert versus more of a professional witness or maybe when you've been subpoenaed on a case of your own. So we'll talk more about that. And then we'll go through some a specific case that really inspired sort of kind of all of my work when it comes to this. So what I want you to do first, and of course, this is a play therapy training, so we do have a little bit of interactive activities to do. Like I said, we're modifying it. So I'm just going to ask you to do these independently. But we're going to leave a couple minutes to do these because I do feel like this training specifically is really about self-assessment and working on our own biases. So what I would like everybody to start by doing is on a piece of paper in front of you or somewhere near you, write down, typically I use stickers, but we don't have that. So write down maybe 2 or 3 words or images that you would use to describe you just as a therapist. And so once you've done that, maybe in the box next to that or somewhere near that list, write down 2 or 3 words or images that would describe how other therapists view you. So maybe your colleagues, maybe other people that you've worked with in the past, other people within the system, how other therapists view you. And then lastly, on this part, a few words or images that describe how you believe your clients view you. All right. Is anybody comfortable or willing to share? When you look at those 3 sort of clusters of words, sort of the relatability or how much they are sort of consistent with one another or how inconsistent they are with one another. Is anybody willing to share that?
I think my examples are pretty consistent with each other.
Same. Yeah, I think mine are fairly consistent. Yeah.
Is anybody comfortable sharing maybe one or 2 of the words?
I wrote friendly, understanding, but also inexperienced for how I view myself as a therapist.
Yeah, mine's like vastly different between the three. And I don't know if it's just because getting into different people's perspectives,
Sure.
I'm
Sure.
super empathic, so I pick up on people's cues. So like in one category, a lot of my colleagues have told me that I'm ambitious, and social justice oriented, but then from families, I get the sense that they're like nervous at first to work with me. And for myself, like I feel like I'm a pretty caring and nurturing person. So still learning how to get that vibe across to everybody.
Sure. Sure. So overall, it sounds like for this activity, the beginning of this activity, most people chose words that you have some evidence to support, right? So either your colleagues have shared with you their opinions of things, clients have said things to you, you kind of spent your life recognizing that you're a caring, compassionate person, those things. And it sounds like these were all words that were fairly easy for you to come up with. It didn't take long for people to find some describers when they were navigating their self-assessment. So whether it's on the back of this paper or next to this paper, write down a few words to describe how you feel about working within the court system and how you believe the courts feel about working with you as a therapist. So what are the initial feelings or, I guess, surprises that you recognize when you wrote this down?
For me, they're very different words than my first list.
I would agree with that. I leaned more into the feeling nervous, scared aspect.
I added a layer because I think there's a difference between the court versus like the parents' lawyers.
Okay.
So I think lawyers prey on the generosity of therapists, and so I feel like almost like they're trying to take advantage of a situation, which I don't know if it's actually true, but it's just like, the sort of like energy that I've gathered from other
Sure.
colleagues in the field. And then I imagine the court itself would be pretty welcoming. But it's the lawyers that is where like my terrified
Sure.
word comes from. Get Elvis legs.
Well, and I think your perspective is probably shared by many people about the feeling of, them praying or them, sort of using you to get information. And so we're going to talk a lot about that. Any other feelings or thoughts that anybody wants to share regarding that?
I have a pretty similar in all of them because this is kind of a refresher course for me. So I was actually subpoenaed today, but they got it continued. So I like having my expertise, being able to share it in court. And
Great.
I think you just said something. The court itself is really like I would say the judges feel like they like me because I really like when the judges ask me questions because they want to know. They want to know what's going on and what's best for that kiddo. Some of the attorneys don't always like me, especially the one that didn't subpoena me. But yeah, so I think it's really cool for us as therapists to be in there and educate the legal field in all of this stuff that they need to know about therapy because a lot of them don't know.
That's great. Great. All right. So take a minute and just think about, why are you at this training, right? Why are you here? Is it to increase your confidence? Is it for some credibility? Is it to increase your courage or your knowledge? Are you trying to looking for a way out, trying to get out of the subpoena, trying to get out of, being triangulated by the attorneys? Are you looking for change? Like you're wanting to change something about your approach? Do you feel like it would give you some respect? Or are you looking for a solution? Is anybody feeling like initially kind of, if they're being honest, they're looking for a way out.
I would venture a guess, Kate, you're probably right there, right? And it's interesting that you, like, I hadn't thought of it too, but I was like, as you say that, right? I'm like, oh, why are you going to give us some tips, right? To get, like,
That's what I get from a lot of people, right? Like, how do we get out of the subpoena? So I think that's a pretty shared feeling, at least to some degree, right? I'm sure that many people want to increase their confidence or work on just learning some skill, but many people also in the back of their mind are looking for a way out. We will address that, but like I said, my perspective is really to lean in. So we're not going to spend a ton of time. The majority of the training is not about looking for a way out. We will talk about that to some degree, though. Typically, I go through our ethical responsibilities to remind us ultimately, or to challenge our idea of working within the courts. I'm not going to go through all of them, but I think it's important that many times within maybe our education or our profession or in our agency that we're working for, we often sort of get the feedback that it's ethical to not participate in court, right? It's ethical to protect our client's confidentiality, or it's ethical to not give information to an attorney or over assert ourselves in some sort of subsystem of what's going on. And the more I've really worked in this area, I've really recognized that it really is our ethical obligation to lean in and work with the court system. So if you were to look at and I use the social work ethics, but they're very much across the board with mental health counseling. If you look at the ethical responsibilities we have, the way I perceive those ethical responsibilities, I really wanted to highlight how working within the system is supported by that ethical responsibility. And so, for instance, if we were to look at the ethical responsibility of pursuing social change, right? We have to look at that. We are not working against anyone. As a therapist, it's not our job as a social, not our job to work against. It's our job to work with. That's how social change happens. We make social change by increasing sensitivity, awareness, and education, by helping the people that we're working with be empowered, and really by using the power that we do have for good. I think that maybe is where things can be a little bit, debatable sometimes. Is it feels as if we're being asked to use, and I use the word our power, but our role, the knowledge that we have, when we're asked to use it, maybe with the intention of disempowering somebody. But ultimately, right, it's our role, it's our job to find a way to use the power that we do have for good in respect to what the ethical responsibility is that we have. It's hard to change if we're not looking at how that impacts the system we're working with. So often in mental health counseling and social work, we are very client focused, we're very individual focused. However, we all know that change, any kind of change, really takes change on multi-levels or throughout the system. And so what I would encourage you to do, if you get the slides, and I'll just kind of breeze through them, but take a look at the ethical principles and consider how you believe they are impacted or they would be supported by the idea of leaning into working with the system. So the principle of clinicians respecting the inherent dignity and worth of a person, the idea that we could give the client a voice, we can model advocacy, and the client gets to choose who gets to represent them or who gets to speak on their behalf, which gives them some capacity to advocate for themselves within the system and feel worthy or feel have dignity and value. We're going to talk quite a bit about, as mental health clinicians, we need to practice within our area of competence, and to provide information within our area of expertise. And so we're going to talk about how to really hone in on how to make sure that you are speaking only in your area. But I believe, like Kelly shared, who knows more about child development and mental health of a child than their therapist, right? So really, you are the expert in this field. Recognizing that we do have to behave in a reasonable and trustworthy manner, and we have ethics, we have professional judgment, we have parameters to help us with that. Again, your competence enhance your professional abilities. So what I believe ultimately is that it's our ethical obligation to our profession and to our clients and to the community to work within the system. I believe in the effectiveness of systemic work. I've seen too often that if we don't lean in, if we don't participate, who's going to? It can be a very positive event or opportunity for not just us, but for the client, for the members of the system. I very much believe that we have an opportunity to take the responsibility off of the child by stepping in. It clarifies our role. It clarifies what our job is. It clarifies what we will or will not do, or what we can or cannot do. We get to be in control. And I think I mentioned sometimes feeling like we're being asked to say certain things, or being preyed upon, or being sort of words are put into our mouth. Hopefully by the end of this training, you're going to feel a lot more capable or more confident in your ability to really be in control of that part. If you know much about Adlerian personality priorities, I am a proud superior personality priority. And so working within the court system feeds that part of my personality. And I strongly believe in a client's right to self-determination. And by being able to advocate and work with them within their system, I believe that we are helping them with their self-determination. So taking a minute, thinking about, what do you fundamentally believe? Do you believe that we should avoid working with the courts? Do you try to be Switzerland? Or do you lean in? I always think of leaning in, and the picture kind of captures that. When you have a dog in your car and you take a sharp turn, that dog instinctually or intuitively knows how to lean with the car in order to keep their footing. And so, the courts are asking for our expertise. And for me, that's an encouraging sign that mental health and play therapy is being more recognized in the court. And it's my opinion that, conflict is human. When we avoid conflict, we're actually moving closer to tyranny than to peace. So conflict itself isn't imprisoning. What keeps us trapped is the rigid thinking or the idea of avoiding conflict. So when we want change, we have to be willing to walk into it and not away from it. Any supporting views or opposing views to that? Anybody Switzerland?
The middle child in me really wants to be Switzerland, so.
Okay. Yeah.
But I'm seeing your perspective, and part of the reason that I'm here is to get more information for myself to be able to make a decision about this. Currently, I'm very much Switzerland, where it's I have fees up the wazoo if you even try to get me to go. So.
Sure. Thank you for being honest. I appreciate that.
I don't know others, but I have been testified, in court on cases, and it was a hard experience, and it took an enormous amount of my time, ridiculous amount of my time. So I'm a little bit that's again why I'm here too. I kind of laugh. I'm like, oh, I wish I'd had this training 4 months ago. But now I know I'll have a lot more information going forward, but I'm real mixed. It was a very difficult experience.
Sure.
And it did impact the, having the parents both trust me. Mm-hmm. So that's where I felt very saddened by it, because I lost the, respect, maybe not, but the trust safety level with one of the parents who didn't see that I was on his side. So
sure,
that was hard.
Sure. Yep. All right. So the first part that I really like to offer is what I call sort of these guideposts. So when we think of walking into a situation where we feel a little bit anxious, we feel a little uneasy about what our role is, we feel like we're not quite sure, what we're going to say or what we're going to be asked. If you compare that, if anybody's familiar with child-centered play therapy or CPRT by Gary Landreth, right? The picture in the background here is a picture of what he suggests to use for a play session if you do the CPRT curriculum for parenting, right? And the idea of that is that instead of being a parent who's always reacting or is feeling like, my child's going to do something and then I'm going to have to respond in a certain way that I don't always feel prepared. I don't always know why I'm responding this way. I don't always feel very in control of what's going on, right? Gary talks a lot about how important it is to hold structure first. And if you can enter something with structure behind you, that is where your control is, so that you're less reactive, so that you're less impulsive, so that you're less swayed by what's going on. And so looking at that image reminds me of how important it is to define what your role is as a therapist. You need to set the structure before even introducing the idea of you being involved with the system. And that could be from intake, right? From the intake that you have with your client, really looking at what is the structure that you carry as a therapist. And then moving forward, what is the structure that you carry when you move into a family team meeting, or when you're talking to a DHS worker, or when you enter the court? If you set the parameters with others and internally, then you have that to fall back on. If you have not set those parameters, if you don't have that self-awareness or sort of that framework around what you're going to say, what your policies are about things, all of that, what your relationship status is with your client, that kind of information, then that's sort of where the ambivalence or the uncertainty can feel like it gets preyed upon, right? It can feel like that's where there's sort of those like, I guess, like unarmored places in you that can feel attacked or can feel taken advantage of. And so the first guidepost that I really can't stress enough is defining your role to yourself, to the other people within the system, and knowing how you're going to set your structure. And as we move through today's training, I think that you're going to get a lot of information to help you figure out what that structure is going to look like for you. The next guidepost is remembering that you are the expert. And it's really important to pay attention to identify what do you know for sure. It's equally as important to identify what you don't know. And so by really like delineating those two things, by looking at what I know for sure is this stuff. I know for sure about my work with the client. I know for sure about what my role as a therapist is. I know for sure about my area of expertise. For me, I feel very confident testifying about trauma, about children, about attachment, about sort of that niche. If I were to be called into court and somebody were to be asking me to talk about, let's say bipolar disorder as an expert, that is not my area of expertise. If I haven't identified that to the system, if I haven't identified that to myself or to my client, that's where I'm opening myself up for that vulnerability or for that lack of confidence, or for like that feeling of anxiety that we all kind of dread. So really paying attention to what do you feel confident that you can say you're the expert about? And are you able to see yourself as an expert? As a therapist, as somebody who works with children, you are the expert when it comes to that work. What are some of maybe the biases or the feelings that you have about these first two guideposts that we've talked about?
I guess I have more recently been called to testify in like child custody cases, which feels very different than like the other system involved cases I've worked on. And I feel like I've tried to set my role, and the different parties like just try really hard to pull me in different directions. And that's been really, really difficult. And I don't feel like in system involved cases, there's like a DHS worker or a GAL that has been a little bit more protective. And that's not the case in a custody case.
Mm-hmm.
So that's, yeah.
And so I would encourage you, when we start talking about those like custody cases or even just kind of private court cases, really paying attention to what are you the expert about on that case or with that client, right? So you may be the expert about your sessions, but you may not be an expert about how they're parented in their parents' home. And really being able to separate those things and finding language at how to separate that. And you'll get some ideas of language as we move forward. But even when it comes to sort of case by case, what do you feel like you're the expert in? What is your structure, and how can you communicate that structure to the family, to the parents, to their attorneys?
Something else that I think about is I'm an associate. And so I don't know, I guess the title makes me literally not an expert yet. So, although I do have 20 years in child education and working with families, I just feel like as an associate, like, would my supervisor need to attest to my ability, or like, I don't know, but I have heard of some of my associate colleagues being called to court. And I guess the other thing that I'm thinking of is some clients that I have taken on where I'm building expertise in autism, and I don't necessarily have it yet. But it's something that I'm learning about and exploring and working with the families and with consultants to learn more about. So in those situations where it's like, I'm working on building my scope of practice, how do I communicate that with the families, the lawyers, and the court?
Mm-hmm. So I really appreciate your honesty. I'm gonna sort of, hold on to that until we get to one of the next guideposts to talk more about some of the things that you shared. So putting what Chessie said aside for a minute, the next guidepost that I strongly encourage and we talk quite a bit about is staying in your lane. It can be very hard to do that if you're a people pleaser. It can be very hard to do that if you're feeling insecure or unsure of yourself. It can be hard to do that if you're feeling intimidated, if you're feeling unprepared. So really paying attention to what is in my lane, right? What is my role here? Is my role to speak about my interactions with the child? Is my role here to talk about what I know about domestic violence? Knowing your role, knowing your opinions, and knowing your facts. So those are two very different things. When you're as an expert witness, you are asked about your opinions. So whether that's a blind witness, which is what a lot of what I do, I'll be asked to enter as a blind witness or an expert witness on a case that I know nothing about. And I'm asked to talk about my profession, about how children are impacted by trauma, by domestic violence, that kind of thing. So I know nothing about that case, but they are asking for my professional opinion, and I can support my opinion by the stuff I know, right? The research, the training, my experience. That's very different than being asked to go to court and just sharing facts. I've met with this client 23 times, right? And really knowing that there is a very big difference between those two things. And often in our profession, most of the time we are asked to speak about our professional opinion. So it's not to say that we should not be sharing our opinion. We just have to make sure that we know it's our professional opinion and it's not a fact. And we'll talk more about how to sort of use that in a way that feels valid, that feels supported. It feels like it's the information that they are being asked for you to share. I think sometimes that's what throws us off a little bit is, we feel like, oh, I don't know really what is my opinion, or my opinion is kind of the dangerous, slippery slope. But if you go back to the guidepost of being an expert, if you can confidently say that you are an expert in play therapy, then you have the right to share your professional opinion about the play therapy that you do. It's also very important to know your boundaries, right? Know what you will talk about, know what you won't talk about. So just because you're subpoenaed to talk doesn't mean that you have to talk about everything you're being asked. I would say it's more important when you're subpoenaed to lean into the subpoena and then start to navigate this part instead of try to stay out of the subpoena. Because the more you fight, the more you resist, the more vulnerable you are. Right? But if you say, all right, like I'm subpoenaed to court, right? I'm subpoenaed to talk about what parent I think is a better parent, right? Well, I know my lane. I know what my role is. I know what my opinion is. I know my boundaries, right? So they can put me on the stand and they can ask me, do you know this child? Does this child have a diagnosis? What would support that diagnosis? Do you see this child interact with their parents? All of those things are within my lane. And then when they say, do you believe this child should be placed with their father? It is 100% acceptable and ethical to say, that's out of the scope of my practice. I'm not qualified to answer that. I'm not somebody who evaluates parenting, right? So what you're doing is you're leaning in and you're in control of what you're leaning in with. But if it's that like immediate feeling of resistance, like I'm not going to court. Nope. I don't want to go to court. I don't have anything to share, right? Then we have to look back at our ethical standards. And is our client feeling supported? Are we using that client's right to self-determination to help advocate for them? Your job as a therapist may be to advocate for your child, for the child that you're meeting with. And your job as a therapist may be to help sort of give a voice to the fact that this child has significant anxiety. And what you know is the child's anxiety, much of it has been triggered by the parent conflict. That is all within your lane, and you have evidence to support that, right? The fact is, my client has reported feeling anxious when they have to go between parents' homes. If the client has reported that to you, that's a fact. But then if the attorney says to you, do you believe the child is more anxious when they have to go to their dad's? My job is not to fall into that answer because they're asking you it, right? It's to go back to what is in my lane, what is my structure here, and to say, all I can tell you is that my client has reported feeling anxious when they have to go between parents. What do you feel like what do you feel like it feels like to hear the response of sort of the more leaned in response, right? Versus the resistance? What does it feel like to you to experience sort of both approaches?
It feels more assertive.
Yeah, I think I agree. Like it feels connected to what you were talking about earlier, right? Of us being the experts, right? I think that initial feeling of resistance can come from those feelings of intimidation, right? And attorneys are scary and the court is scary. But being able to lean into the areas, like you said, that we know to be facts and the areas we are experts in. And I would love to hear more, Kate, I know you're kind of talking about it, but when you mentioned, that not leaning in makes us more vulnerable, can you share a little bit more about that as well?
Mm-hmm. So if that feeling of the courts are scary, right? Or this attorney is being a bully, or whatever that is, whatever that perception is that we have, right? What we know as therapists, what we know as empathic people is what we believe about things is projected by our reality. So if we walk into the courtroom feeling intimidated, if we walk into the courtroom thinking, I'm not really an expert in this, that is the message we're sending to other people. I mean, that's how it is in all of our relationships, right? If I believe, I'm not very good at something, most people around me are going to believe I'm not very good at it. It's because it's my reality. It's what I'm coming in the room with. And I mean, ultimately, an attorney has a job just like we have a job. Their job is to discredit, right? So that's really the goal of, an attorney's job is not necessarily to argue with your professional opinion, because the truth is they can't. That's not their professional opinion. That's not the role they're in. But their job is to discredit you or discount you, to make it irrelevant. So if you've already sort of entered it insecurely, like, well, I mean, I kind of think this, or, they can sense that like ambivalence or hesitation, then they're going to continue to use that to just discredit. Remember, I mean, stereotypically, right? An attorney's job is to just imply reasonable doubt. So if, as a therapist, you're saying, well, yeah, I mean, I think that the child is more anxious to go to dad's. I'm not 100% sure, but it seems like it. And that attorney has kind of built the ability to say, proof of that? How do you know that? Have they ever told you that? And all of those things are kind of flustering you and kind of getting you like, maybe I don't know how to support that, right? That's enough to just discredit. But if you say, what I do know for sure is that the child has anxiety about going between parents, but it's not within my scope to, put words in the child's mouth or to say what the child may or may not feel. There's nothing to discredit because you've stayed in your lane. And attorneys, I mean, the reason they have all these people on their subpoena list is because if they're not going to get what they want from you, they're going to go to the next person and try to get it from the next person. It's not your job to give anybody what they want. And so that's really the idea that I have regarding, coming in as the expert, is not feeling like it is your job to give an answer that somebody is asking you to give. You are the one in control of that. You are the one holding your information with your structure within your lane.
I know you're probably going to answer questions about being the expert witness. What I felt was so awkward was the other parent had an expert witness come in that didn't know the clients. I mean, they met with the children one time, and it was so strange to me. And I was new to that process, and so I do think, just to reassure everyone's, if everyone is a little bit nervous about being the expert witness, they leaned on my testimony so much more because of my extensive work with the children. So that is what, when you say know your facts, well, I knew a lot more facts.
Mm-hmm. Mm-hmm.
And
right.
And I had an attorney that guided me in what to say, not to say kind of things. And that was helpful. But I used that line, that is out of the scope of my practice, so many times.
Right. Right.
I mean, it was ridiculous. Like,
mm-hmm.
No, I can't answer that, and, but, oh, I can, I mean, I was definitely nervous. I was exhausted after.
Mhm.
Let's just
Yes.
say that.
Yes. Right. And the
Wait,
role, I'm sorry, the role of an expert witness, like what you're talking about, Trisha, when I'm coming as a blind witness, right? My role is to just support a condition, right? I can't, it's actually, and I don't want to say it's illegal, but it's not okay to give me any information about the case. So there should be no sort of competition between me and the actual therapist, right? It just allows us to maybe support one another indirectly. But that's really how it's a different role.
I think that's ideally how it should be.
Right. Right.
But it was hard to feel that in the moment.
Sure.
But I did have a communication, but like on a break with the expert witness, and it was very friendly and on a team. But then it didn't feel that way when it was on the stand.
Mm-hmm. Mm-hmm.
So I was like, oh, okay.
Mm-hmm.
And Kate, we had another question, just kind of reiterating what you've been saying, right? And the question was, so it's best to be most confident as possible so that you don't get nitpicked on your wording on the stand.
Yes. Yes. Right. And that's really, having that structure in place, right? Knowing what your wording is, knowing what your language is. Mm-hmm. Knowing that it's okay and recommended to bring up notes if you need to, but also knowing that if you bring up notes, they're all subject to everybody else in the courtroom. So if you have notes up there that just have phrases of what you want to say, right? Or little inspirational messages to yourself, that's fine. There's nothing wrong with that. What you don't want to do is have notes that share information or even word it in a way that would not be something that you would be okay with everybody else seeing. So whatever you bring into the courtroom with you has the opportunity or has the chance to be seen by everybody else. But there's nothing wrong with bringing notes up on the stand with you. Another guidepost, and this goes back to what Chessie was talking about initially, was your ego check, right? Is really, really being aware of your ego when you walk into a courtroom. What is driving you in that moment, right? Are you just angry? And are you feeling defensive? What is your personality priority? Are you a pleaser? Do you like to have control? Are you more of a superiority person? Are you comfort-based? So if you're not aware of that through sort of the Adlerian perspective, I encourage you to look into that. It's very, very helpful. But just that self-assessment of knowing if I know that I'm a superiority, right? If I know that that's my personality priority, I know that certain things are going to really kind of get to me and other things are not going to be that big of a deal to me. So pleasing somebody isn't that important to me, but feeling misunderstood is important to me. And those are sort of like the things that I have to be aware of. That, okay, so if somebody is misunderstanding me, if somebody is trying to twist my words around, I know that's going to be one of those areas that I'm going to feel a little bit defensive or a little bit like, ooh, I don't like that. That's kind of a vulnerability, right? But if somebody else is a pleaser and that person is displeased with your response, or maybe the client, you're looking at that client's face and you're seeing that they're hurt because you're talking about how many sessions they did not attend, right? Then that's going to be an area of vulnerability for you. And that's going to be a place where you know that you have to be aware of, ooh, that's something that I have to check at the door, or I have to just sort of embrace when I'm up there. So for me, obviously, because being misunderstood is hard, I don't like that, right? I am very clear about what I'm saying. And if somebody tries to re-say what I say, but put it in different words, I will often own my words again. And that's not to be argumentative. It's so that I know I had sort of that opportunity to be heard the way I felt I needed to be heard. But along with that, right, I also know how important it is to hear other people. And so if I don't understand a question, if I feel confused by something, if I feel like somebody's trying to sort of catch me caught off guard, then I will give myself the time and the space to ask them to repeat it, ask them to rephrase the question, because I know for me how important that communication piece is. And recognizing for your ego, who are you trying to please? Are you trying to please the lawyer? Are you trying to please the judge? Are you trying to please the client? Trying to please your supervisor? Who are you trying to please? And that, again, we all have an ego. I mean, that's a part of all of it. But our ego does drive a lot of what we do. And if we come in, I just read a quote recently, if it comes from an ego, it's complicated, right? If it comes from sort of the purity or from like the more intuitive, holistic part of our job, it's typically simple. If somebody asks you a question and it's easy to give an answer, it's a calm, regulated answer, that's typically coming from sort of the greater good of our profession. If we're feeling defensive, if we're feeling protective, if we're feeling insecure, that's probably coming from our ego, and we're stumbling over our words and we're getting kind of caught up and insecure. And so being aware of that, I know that being an expert is also part of my ego. I know that I like to know what I know. And sometimes I don't need to share as much as what I know. Like, that's just my ego wanting to be heard. That's not necessarily what I'm being asked.
Somebody shared in the chat that it's usually a bad experience in court that brings us to these kinds of trainings and wanting to learn how to deal with that. And I can't help but think about how a negative court experience may even kind of make that ego check more necessary, right? Coming in potentially on the defensive and really wanting to reclaim that experience or demonstrate.
Right. Mm-hmm. I'd be curious though, thinking of the negative court experience, did it feel negative because you felt that the client got disempowered or taken advantage of, or they lost what you believed was maybe in their best interest? Or was it because you felt disempowered or unprepared or misunderstood?
That was my comment. And it was because I was, I'm trying to think of the right word, basically attacked.
Sure.
So like by the opposing attorney, and it resulted in a complaint against me and my supervisor at my job at the time to the Department of Children's Services in my state.
Mm-hmm.
So it was like it was mostly like that. It's pretty much the gist. And just for if anybody's curious, DCS wasn't worried about it at all. They just gave me a couple tips for next time. So I didn't get in trouble, but it freaked me out. So it was that. Yep. And I felt like what I said and did was appropriate for the child at the time. And the whole case was really dumb. Like reflecting back on it now, it was for a very minor issue anyway. So it was completely overblown by this other attorney, but that's what it was about.
Well, and ultimately, right, your resolve in that, or your ability now to sit in that is you've separated that, ethically, I felt okay about what I did. I felt supported by what I did. I felt like I did the right thing. And so the stuff, like the result of what happened, an investigation or whatever, in the moment, the negative part is the ego part, right? It sucked. I felt bad about it. I didn't like what happened. But going back to the fact that it sounds like you went in there feeling pretty confident of the structure that you brought in, of what you were saying, of the words. And so when you go back to your ethical responsibility as a therapist, that's what your ethical responsibility is. That's the only part that you have to own. And trusting or seeing that the sort of the bark, the reaction to it was much bigger than the bite, right? So the ego, that's usually what happens in court, is that we get sort of flustered or we get challenged and our ego starts to act up. It's when it's way more concerning, and it is our responsibility if it's our like our ethics or our professionalism that we start to question then. So to some degree, I wouldn't even name that as a negative court experience. It sounds like you did a great job.
Well, yeah, reflecting on it now, I think it served a lot of great purposes.
Mhm.
I feel like I've
For
helped
sure.
a ton of kids since then, just from
Great.
all kind of just dominoed from that experience. So
Sure.
I don't regret it.
Great. Great. All right. And then another guidepost is to really know yourself, right? Know yourself as a therapist. Prioritize your values and beliefs. Know what you know and work on your confidence. It's okay to know what you value. It's okay to know what your beliefs are. It's okay to know what your opinions are. It's okay to know that you really hate working with that attorney. It's okay to know that that is typically somebody who supports reunification no matter what. Whatever that is, know those things and recognize that you know those things, because that's only going to help you set a different structure for yourself. It doesn't mean that you should testify to the fact that you don't like that attorney, right? But it's okay to know that about yourself and really own what you know, or know what you know. A lot of it is about, sort of this idea that as a therapist, we're less than everybody else in the system, right? And some of that for sure is feedback that we've gotten over time. Part of it is because the majority of us are women, right? There are roles that we have played or that we sort of buy into. One of the first times I testified was talking about a sand tray session, and an attorney was, trying to discredit me and said, so you're telling me that you have a sandbox in your office and you call that therapy, right? So if I went into that not knowing what I know and feeling sort of like insecure as to what is the purpose of sand tray and why do I do play therapy, that would be a really not so good interaction, because then I would fumble and I would sort of feel disempowered and I would feel offended, or my ego would take over and I'd get defensive, right? And if you think about everybody else in that courtroom, do they believe that that attorney is a sand tray therapist? Or are they going to give me the benefit of the doubt initially that as a therapist, I probably have some more knowledge about it than the attorney? So I have to go in there knowing why I use a sand tray, knowing what is the purpose of it. Because when that attorney tried to discredit me, my response was clarifying. I don't have a sandbox in my office. I have a sand tray in my office, and here's the purpose of it. And so that wasn't argumentative, it was clarifying. And so knowing why are you doing cognitive behavioral therapy with this child? Why are they diagnosed with an adjustment disorder? Because that's what you fall back on. That's how you fall back on how to respond to things that feel attacking, negative, discrediting. Another guidepost is really remembering and knowing that your opinion is wanted, right? I think we really get in some sort of belief that, and I think some of this comes from school, that we're not supposed to share our opinion. And it's important to remind yourself that they are asking you for your opinion. It's important to know, am I sharing a fact? Am I, or is this my expert opinion? Is this a professional opinion or is it my personal opinion? Those are all things that are very, very important to be aware of. But the truth is, I can't think of anything in court or any reason that you'd be called into any sort of systemic work if they did not want your professional opinion, because they're calling you in as a therapist. If they were calling a physician in, they would be asking for their professional opinion. Any thoughts or questions or feedback about any of that so far?
I was thinking just relationship wise that it would be difficult for parents to hear your opinion the first time in court, which is why I think it's really important to have parent consultations, so that they're not caught off guard. Like they should already know what your opinion is about, how they can support the kid. And so I think in that
For
way,
sure.
it makes me like more confident about being able to share my opinion without it impacting the relationship. And I think that that's probably the biggest like mindset barrier that I was having previous to this, that like being court involved would impact the relationship poorly. I mean, it still could, but at least in that way, I feel like my system is set up in a way that supports the family understanding what's already going on.
For sure. Like the transparency is really important, right? So when we think back to that first slide, the structure one, right? Part of my structure is before anything happens, I need to talk to the attorneys. I need to know what they're asking, and I need them to know what I'm going to share, or what I won't share. So it's kind of like a little dress rehearsal ahead of time of, what are the questions you're going to ask me? And, here would be my response, or I'm not going to speak about what parent is better. That's not within my scope. I'm not going to answer any questions about that. And honestly, I feel like it's out of respect for the client because, number one, they're going to know my parameters going into it. But I also don't think it's fair to charge my client for me to show up to court if it's not going to benefit them at all.
And Kate, along those lines, we had a question in the chat and they kind of acknowledged, maybe we'll get to this, but how do you handle situations where you've been subpoenaed, but the attorney doesn't do any preparation work with you?
So I can't leave it up to them to do it, right? I have to seek out them. So the minute I get the subpoena, and sometimes I know ahead of time, but not always, the minute I get a subpoena, I contact the lawyer with permission from the client, and the client's aware of it. And I reach out to the attorney and just kind of have that general conversation. I don't know, I don't always know like whose attorney this is and what are they calling about. And so to be honest with you, if I lean in that quickly right away from the bat, much of the time I don't ever get to court. Right? Because I've already said, in a sense, I'm in control of this. I'm going to tell you what my structure is. I'm going to tell you what my parameters are. I'm going to tell you what I'm an expert about. You can decide, speaking to the attorney, you can decide if that's going to be what you need from me or not. But here's what I'm going to say. And many times, and we'll talk more about this down the road, but how do we do all the work before it even gets to that? Right? How do we offer a letter? How do we offer just a conversation with an attorney? How can we be a part of a planning team before we even have to be subpoenaed? And again, if we lean in and if we maintain some control over our role in this and the lane that we're in and what we believe is our responsibility, and if we have sort of that stuff to back it up, right? I can refer to the ethical responsibility I have and the limits within my ethics. It is 100% acceptable to be on the stand or to be talking with an attorney and say, it is not in my client's clinical best practice, best judgment, best interest to talk about that. And most of the time, the judge will support a clinical decision like that. It's very unlikely that the judge will go against what you feel as a medical professional would do harm to your client.
And playing worst case scenario, okay, any tips for kind of what to do if there is a situation where the attorney is not reachable? You get a subpoena and they're not responding to voicemails or emails or any sort of contact attempts from you.
So in that case, the first thing I would do is contact the client and just see if they can sort of help navigate what's going on. The second thing I would do is try to figure out who the opposing attorney is or who another legal member of that system is. So is there a GAL? Because many times if you can reach out to one of them, then they sort of, can do some of that navigating. In many circumstances, it's harder to do this, but if that is happening and if you've made, say 3 attempts to contact the attorney and you're not getting anywhere, you can file a motion to quash the petition. And the reason that you'd be asking to quash it is because of that lack of communication. And most likely that would be responded to. And so if you really feel that they're being avoidant or resistive, and you feel like you've done your work, like you've done the due diligence to try to reach out and figure that out. And again, recognizing that, and again, this may sort of trigger some conversation, but none of us are the victim in this, right? So they're not doing this to us. We're not the victim. We are an equal player. And so it may feel frustrating because you're like, well, now I have to like take all this time to make these phone calls and track these people down. I mean, we could view it as they're doing this to us, and that really sucks. But that's going to do nothing except disempower us. Right? So the way I like to look at it is your responsibility now to respond the way that you feel best about. It is not their responsibility to make it easier for you or more cooperative or whatever. It's not about us actually at all. And so it's really important to a perception, right? If we see ourselves as the victim and they're the bad guy, that is the way it will play out. That is how we will respond. We will come from that place. And so it's really important to see yourself, to value yourself enough to say that you are on equal playing field with everybody else in that room. This is just your lane. This is the area that you are the expert in. They are the expert in their lane. Your client is the expert in their lane. Nobody is like better or worse or has more power aside from the judge, but the judge is actually deferring because the judge knows he or she is not the expert. Any other thoughts or questions or comments about that? All right. So what we're going to do before we take a short break is we're just going to take a minute to look at what our own areas of expertise are. And the reason I do this is, again, sometimes we don't take that time to build that self-awareness or to sort of like start to build our own structure, our own stuff going into it. So if you imagine sort of like, and what I use if you were in person was sort of a paper plate, okay, like one of the cheap picnic paper plates. In the middle of that paper plate, I want you to imagine, and you can draw on your paper, imagine a statue or a figure that would symbolize what your area of expertise is or areas. And so really sort of know, like, yeah, I would feel pretty confident of saying, you know, anxiety in children is my area of expertise. Or I would feel pretty confident saying that working with teenagers is my area of expertise. Whatever that looks like. And it can be several things. So that's kind of the statue, right? That's the statue that you want to not just protect, but you really want to support. And you want to give it a space. And so around that statue, what would you put around that statue metaphor that would indicate that you know that really is something that is an area of expertise. So again, if you're walking through a museum and there's a statue, typically, right, there's some sort of like metal plate describing why this is so important and who made it and what the training of the artist was, or any of that stuff that sort of supports the fact that that is your area. So does anybody want to share a few things that would support the area of expertise that you've identified?
I would say I do good with teens going through divorce.
Okay.
Parents. The reason I say that is because I personally have gone through it at a teenage level, and I learned a lot more when I got older and understanding it more.
Okay.
And then also I've dealt with my teenage cousins that their parents have gone through divorce, and I feel like I am very confident and really knowledgeable with teens, especially boys, when it comes to it, because
Okay.
most of my cousins were boys.
So one thing that I do want to point out is if for instance, just like you're saying that you have some personal experience in an area,
Yeah.
if you share that as part of your
Oh.
credibility, it's important to know that that can also be an area that they ask more about.
Yep.
And in the experience that I've had, this is just my own experience, the minute you open up anything about your personal life is the minute you are discredited as a therapist.
Mhm.
So I would encourage, I would strongly suggest that when you share information to support your area of expertise in a systemic way, like in a setting like that, that you really, aside from maybe saying, you know, I've lived in this community for 20 years, or I am, you know, I'll share that I'm a foster parent. So that gives it a little bit of, relatability, but I
Not
don't use,
opening a whole lot. Yeah.
right. And because again, expert is different than personal, right? So they want to know how professionally you are an expert. And so I agree with you, Jess, that your personal experience has 100% added to your knowledge and your ability to be aware of things and has given you a huge framework. In
Mhm.
court, that is an area that they can really start to discredit. And it's an area that, honestly, if they start to go that way, you're going to have a more personal reaction to it. I was in court a few years ago with a former colleague of mine, and she was on the stand being asked about her client, who happened to be the parent of my client. And that parent was being charged or held responsible for not having the ability to protect her child. And so her therapist, the person I knew, was talking about how domestic violence has impacted that client, right? Which was 100% in her lane. And that was an area where that was sort of the support she was giving to the client about the client was also a victim of domestic violence and the impact of all of that. However, she did start to share her own experience being a victim of domestic violence in her own life. And that sharing caused her to become emotional. I'm sure that she did not expect that to happen, but she became emotional because she felt vulnerable and she
Right.
felt passionate about it. Um, and and then it sort of like unraveled in a way that she did not feel strong clinically anymore, because she was sort of getting derailed a little bit personally. And then unfortunately for her, in the court report, there was a very clear paragraph discrediting her as a therapist because of her personal reaction, or basically over personalization of the case. And so I think that as much as we know as therapists, we all have personal experiences that would support where we're at. We don't want to allow that to enter into our professional work in those ways, not only because we don't want other people to take advantage of it, but that is also like, that's the transference that we're going to feel. We're going to feel protective of that information. Or if somebody starts to sort of like challenge you, it's natural that you're going to personally feel a little bit defensive. And so I really appreciate being vulnerable and sharing that. And I want to be also protective of that information for you. So is anybody else willing to share their areas of, or an area of expertise, and sort of what gives them the support to know that's an area of expertise?
I can share one. Mine's quite a bit more broad, attachment lens, and I put around my statue in the middle. After graduate school, I did a 2-year program. It was a psychodynamic program, but within it, we had Dr. Alan Srofe come and talk about his 40-year longitudinal study at the University of Minnesota on dyads and how they studied attachment. And then he was able to show us the actual footage of the strange situation and all of that.
Right. So you have a lot of really specialized training or expert training in an area. So that's a great example of, that's how you know that's an area of expertise. You have evidence to support that, whether it's an internship, whether it's 20 years of having a client caseload of victims of child sexual abuse, whatever that is. And then the next part of it, so the final part, the parameter and the boundary, right? So we're going to make a fence around our statue. And so when you think about that, what do you have to put in place to protect your area of expertise? What are the boundaries you have to practice? What are the parameters that you have to practice? And so maybe list a few things that you know that you need to do in order to really protect or guard your area of expertise.
I probably would say, I mean, this is broad as well, but parenting and as far as actual, I mean, parenting, because one, I have a book that I wrote about parenting, so that published author is a piece of that. And then the other is probably more ADHD. I do ADHD assessments here, so I get a lot of clients around that. And then I think elementary age is probably my scope of my niche per se. It's more based on experience, but I can also tell you that when I was in court, I was very cautious to bring up any personal stuff as well, because of I knew the trigger it would bring me when I already felt a little bit vulnerable. I knew that if I went down any kind of road, that it would elicit that emotion, and probably like you experienced with that other woman, totally unplanned. We can't sometimes, predict what's going to trigger us sometimes. But I had to be probably much more stoic than I would be sitting there with a client.
Sure. I think you bring up a good point, though, that your experience, your professional experience, adds a lot of support to your expertise that shouldn't be discredited. That if you've been doing this job for 15 years, if you've been working with children, that kind of thing is important to use as your sort of support or your credibility. And what are some of the parameters? Go ahead.
I was going to say, I can share kind of from a slightly different perspective as well. And what came to mind for me when thinking about those boundaries, and I don't know if others are in a similar position, is I'm currently not seeing direct clients. And so when I think about, my statue and my own areas of expertise and kind of the things that support them, like my education, for me, those parameters continue to be continuing, that continuing education and making sure that I'm staying current in my areas of expertise. Because I know one of the kind of responses is like, well, you're not seeing clients right now, right? And so making sure that I'm protecting that area with continued education and awareness of what's happening in the field and in those areas.
It's always a question, beginning to testify, not only when did you get your license, but what are the requirements for maintaining your license? Typically, attorneys will ask that because of that exact reason, to sort of support or to show that this isn't something that you got 20 years ago and you've kind of let it get dusty and haven't paid attention to it since then, that it's an active process.
I think I would add, so I'm in my own private practice, never to practice alone, even if you are alone. So professional consultation, continuing that.
That's a great parameter and boundary, that that you need to maintain those professional relationships so that you can consult about cases. That you want to, continue continuing ed in that area. Maybe that you want to continue seeing clients in that age group or with those issues so that you stay current. Any of those things. And some of the parameters and boundaries may be what you won't do, right? What that you're not okay doing, what you're not comfortable doing, or areas that you just feel like could be contradictory or could be distraction. All right. So like I said, we're going to start to apply some of this in real life. And I encourage you to, kind of the testifying part, Obviously, that's the part that most people are wanting to talk about, wanting to learn more about, wanting to avoid. But our systemic work starts way before then. And it's really all going to lead up to the testifying part. So I think paying attention and really applying all of those guideposts that we went through, applying those even from the beginning, when we start talking about writing reports, conducting assessments, going to meetings, writing letters in support of, all of that stuff we can apply the guidepost to, not just testifying. And by doing that, it's less likely that you will be testifying. So that's something kind of important to stress, that we need to be really applying all of this way before we get the subpoena. So when we begin, we're not going to go through the confidentiality part. However, it is important to remind yourself of what your confidentiality rules are and policies. Immediately cooperating or offering information is not considered ethical, along with resisting it, right? So not just free for all sharing your opinion. Again, defining your role, your ethics, what is within your ability to share, offering other options. I can't tell you this, but I can share this with you. Making sure that you've talked or you've reviewed what your agency standards are, and what your personal standards are. I think it's very, very helpful if you have personal templates that you use, because you've then put your structure in place, right? Then you've already decided how you would phrase a letter in support of something, or you've already decided how you would write about how to schedule appointments with to household family, right? So if you already have that letter format, it saves you the time, also saves sort of the impressionability of writing more maybe than you want to, or not always paying attention to sort of what those boundaries are. Again, refer to your areas of expertise. And ultimately, the minute you enter a systemic area, whether it's in a letter or in a meeting or in court, know that everything you say will be shared. So you never, ever want to put yourself in a position where you believed you could just tell this attorney this one thing, or you could tell the mom one thing, or the DHS worker, and that it wouldn't be shared across the board. So just really being mindful of that. We need to start thinking about kind of a report in this context. So if you are being asked to write a report, number one, you want to know what your role is. What is sort of this place that you're writing the report from, right? Are you writing a report to the school? And is it a report to talk about what should be included in the IEP, right? So that's great. That's a great way to work within the system. However, are you answering questions? Are you responding to the feedback the mom has given you that you don't know if that's what the school's asking you, right? So really sort of know what your professional role is, and your role is to give your professional observation and never to make the decision. And so I often like to say, our job is to give them the A plus B, right? Or even just the A part of it. Our job is to not ever to give C. We never give what it all equals. So we lay out all of the information, and I'll give an example of that. We may give, what are the symptoms of behavior? What is the diagnosis? What are the treatment modalities? But we're not going to say, what does this mean for the child living in this foster home? We don't have to conclude that. And a lot of times that's where we get sort of like, that's where we overstep, is that we're trying to conclude it for them because we feel there's some unanswered information, right? But a lot of times as we try to conclude it, then we're stepping out of our lane. So when you are writing, let them, whoever them is, conclude your information based upon what you are the expert about. So what you know, plus what you've observed. And then remembering that they are the ones who make the decision. So I know this child has anxiety. I've observed these behaviors. I can't answer. What does that mean? Unless it's a very specific question that you feel is within your lane to answer. When you write a report, you always want to assign responsibility to who and why you're writing it. So let's say DHS has asked you for a report of the client's progress. It's really important to start your report by saying, dear DHS worker, your request, or based on our conversation and your request for an update. And the reason we do that is because as a therapist, when we are cautious about asserting our opinion or our role, basically, like if we're over enmeshed or we have preferential treatment or we're siding with somebody, if we don't assign responsibility to why we're writing it or why we're being asked for it, it can look as if we are the ones choosing to write the letter to the DHS worker, sort of just because we believe we should. And so it's really important to always sort of lay out how it came about that you're being asked to participate in something or write a report. Another thing is to make sure your report is about what you are doing, not what your client is doing. So I'm meeting with this client. We're exploring coping strategies, self-regulation to help the client manage their diagnosis, whatever that is. But it's much less about what the client is doing. And again, that's because we're not the client. That's just sort of our projected idea of what they're doing. We will be asked, or we can write about, are there barriers to their progress? How are they responding to what you're doing? But again, that's more objective versus subjective. And we'll get into a little bit more of that. Identify their behaviors as your evidence, right? So my client is diagnosed with anxiety, or my client is exhibiting more anxiety following, basically since the visits with their parent has started. It's evidenced by, this is the way things were since this date. There's been an increase in dysregulation. The school has reported things, whatever other things that you have to support that. And it's more important to support it, not necessarily to give yourself credit, but to display that you're non-biased in a way, right? So that it's not just because mom told you, it's not just because dad told you or the school told you, it's because across the board you have seen this information. And it's also okay if somebody has opposing information. It's okay if there's another report submitted where somebody else says, well, that's interesting. That's not what I've seen. Have decreased behaviors since this happened. All you can do is speak from what you know for sure. And the best thing to do is put that in writing, which allows the structure of what you would have to defend or what you'd have to talk about. Identify cooperation, progress, and barriers using facts only, not just because it appears that way, like not just because it's like it. There have been barriers to the client's progress because the client has, arrived at sessions avoidant of talking about things, or has reported an increase in substance use, or whatever that barrier is, or progress. If they're cooperative, how do you know they're cooperative? What does that mean to you? Because again, the word cooperation, right? an attorney or somebody else could mean, oh, they're telling you what you want to hear. So checking in with yourself, like, how do I know they're cooperative? Is it just because I feel like our sessions are more productive? Or is it because they're less resistive? Or, how do you know that? What gives you some support in that?
Can I just ask you, what I'm hearing you say is state more evidence, like facts versus your opinion.
Right.
Okay.
Well, state your opinion and support it with the facts.
Got it.
Mm-hmm. Yep. Right. So we don't want to say, my client is doing great in therapy, is making a lot of progress, and I believe they can be discharged from sessions. We don't want to say that unless we have enough information to support it. So summarize your clinical assessment, your objective, your plans as to like, why am I making this statement? It leaves it too wide open if we were to just sort of take for granted or assume that we could make a quick kind of clinical opinion and call it good. We have to give it some kind of backing. And using words like, it is my clinical opinion, it is of concern. Again, using the sentence, it is of concern, does not say, I'm sure. What it's actually saying is, this is an area that we would need to continue to look at, or I want to bring your attention to this area, but you're not assigning value to it. It's helpful to use statements like, you don't want to compare a client to somebody else, obviously. Or you don't want to say, my client is regressing, without having some sort of evidence as to what that means, because most of the people reading this letter or report don't know what that means. So using words that are more objective, like developmentally, it's appropriate for a client to show curiosity when they walk into a room. At age 3, we know developmentally that's a very appropriate characteristic. I can say that, and then I can say, it is of concern that this child who is 3 years old is unable to function or move when they walk into a room. So I'm showing that I have reason to believe that's an area of concern. I don't have to give all of my assumptions, which, I believe it's because of trauma. I believe the child's overstimulated. I believe that the child has had some really terrifying experiences and doesn't feel safe enough to do that. I mean, that's what I believe clinically. But I'd be writing report after report after report if I kept talking about all of that. My report can just point out that this is an area that I'm paying more attention to, because there seems to be sort of an inconsistency or an incongruency between what's developmentally normative or appropriate versus what this client is doing. And then always have something to offer as evidence for your clinical assessment. Utilize developmental, behavioral, and static norms. So here's a sample of a letter that I had written about a client, and I'll just read that out loud to you guys. I'm writing in regards to Shane. I've been providing therapy to Shane and his caregiver since February of 2012. In that time, I have observed Shane to struggle significantly with forming healthy attachments, developing a sense of self and a sense of permanency, and displaying somewhat oppositional behaviors. So the bolded parts are the parts that really kind of go back to the slide before, talking about sort of the areas to highlight in your report. So pay attention to that and see if you can kind of correlate those. Shane's history confirms that Shane was indeed neglected by his parents, suffered traumatic losses of both parents, and as a result, did not form healthy and secure attachments with his parents, and did not emotionally develop according to his chronological development. In sessions, Shane and I have been working on creating healthy attachments, processing through grief, forming trust due to significant separation anxiety following the death of his mother, developing a sense of permanence and a sense of self, and assimilating to his new stable and secure environment. I've also worked significantly with Shane's caregivers on understanding and relating to Shane based on his emotional age and attachment needs, managing his behavior, and assisting him in his grief, anxieties, and hesitancies. Shane has made significant progress, primarily due to the secure and stable, healthy relationship and attachment he has developed with his aunt and uncle. This ongoing primary relationship is absolutely essential for Shane to continue to grow and develop emotionally, secure other healthy relationships, and develop a sense of self. Shane continues to show regressive behaviors, which is typical for a child with such a disrupted attachment. Shane will benefit from ongoing child-parent therapy, permanence and attachment building exercises, trust building, secure relationships, and a stable and structured living environment. It is possible that throughout Shane's life, at significant developmental milestones and adjustments, he will regress or display significant behavior and mental health needs. A child with attachment issues such as Shane will always struggle with self-control, self-development, or self-responsibility, healthy decision-making, compliance, and feeling expression. It is essential that he be in environments and have primary caregivers that fully understand and are invested in his well-being, and be provided the resources to address these needs, advocate for his best interest, and support his attachments and development. So when you think of that letter, I guess what I didn't tell you is that letter was my response to being asked what his permanency plan should be, who he should live with. So when you read that letter or you hear that letter, is there anywhere in there that says, here's who he should live with? But my guess is you can conclude what I'm trying to say, what I'm saying without saying it. What are some of the things that you observed or that you picked up on the letter that kind of stick out to you as a way to support some of the guideposts or the slide before about the tips to sort of write a summary or write a letter, a report?
It was definitely evidence-based.
Okay.
And I oh man, this is invaluable. Thank you. I mean, this is like worth the training. So I appreciate this so much because I am so, this is one of the things I think we get asked to write often, but without even having to go to court.
Right.
So thank you. You need to write a book, by the way, I think. So the letter was asked to write because they wanted to know which parent the child should live with.
Right.
It is brilliant how you answered it without answering it.
Thank you.
So I love that. It sounded so rich with so much information, but you never gave mom or dad.
And I think that this is a great example of our opportunity to advocate for that child, right? It's not about me being the child's therapist and me having control over where that child lives. But what I do know is this child now has information in his file that will go to any caregiver that will support what he needs to be successful. And that's really my goal. My goal can't be who I think is a better parent. I don't have the right to say that. I have my personal opinion, of course. But ultimately, my job is to write for the greater good, right? To give information for the greater good. If I were to lean out and if I were to say, I can't make that recommendation, I can't speak to that. Look at how much information doesn't get communicated. And then we get frustrated when DHS places them with somebody that we're like, ooh, that's probably not the best place for them. DHS workers are not trained in child development. They're not trained in attachment as much as we would like them to be. And so this is my ethical responsibility for my client to make sure that no matter what the decision is, because I don't have control over that, no matter what the decision is, my role, my part, what I can contribute is to give them this knowledge that I have, my expertise, and say, here's what him, empower him. And that's really a child's right to self-determination.
My curiosity comes up around people that say that writing something so detailed and being on record might impact somebody's ability to get into the Air Force like later in life. So what sorts of protections are we putting in place around putting information out there that could be a detriment to kids' future professions?
You know, I've more recently had some of those concerns come up. And to be honest, I don't know that I have any ability to protect that to some degree. Now, I would have no issue if somebody said, can you please not put a diagnosis in a letter? I think that's fair. I mean, really, it's not relevant unless it's relevant to some medical thing. And so I really believe that as long as we don't over identify something like a diagnostic thing and we sort of like put it in gold and say that it has lifelong detrimental, negative effects, I don't think any of this information would harm somebody's reputation moving forward, especially because it's relational information. I don't have any studies to support this client has like a neurological condition or has been evaluated by somebody for bipolar disorder or schizophrenia. So I think there's nothing in this letter that would be diagnostic enough to be carried longer than just in this case.
Okay, thanks.
Kate, similar but completely opposite to that, we did have a question posed in the chat, kind of specific to issues related to diagnosis. And they asked, what if someone has been diagnosed with autism and also has disruptions in attachment? How might that change the writing of something like this? Because that could change developmental stages, especially with certain diagnoses.
So first off, I want to stress, like, do not use this letter for anybody with attachment issues. Like, this is very client specific, right? I could only write this about this client because it's about this client. So I just want to caution you to not like believe that this would support any of the clients that you have with attachment issues. For sure, there may be information in there, but really use your information and plug it into it. Use the information that you have. So if that client has attachment struggles and autism, number one, are you qualified to diagnose both? Or is the autism diagnosis from somewhere else? And you may be able to reflect that or defer to that. Per the parents' report, the child has also been diagnosed with autism by this doctor. I would not speak to that. I may identify it because it's part of their record, but I would not say anything more about it unless I had some sort of like consultation or saw that this diagnosis is something that this child is dealing with. And I may have to indicate that it is unknown or it is of concern that a developmental diagnosis like autism could further impact their attachment. But that's about as much as I would say. Does that answer the question, or does anybody have anything more about that?
I don't have any questions about that, but something that strikes me about this particular letter and being court involved is that in the past, when I've been court involved, I've only listed like dates of attendance. And so this just includes so much more information. And I suppose it's based off of what in particular the court is asking for, or the school is asking for. Yeah.
Well, and I think that's common, right? That a lot of us have been taught like less information is better, right? And many people could challenge that. I mean, you're putting less out there if you put less information. I tend to sort of lean into the side of, but here's my opportunity. Here's my opportunity to share my expertise for the greater good of this client. And then I have to be strategic about how I word it so that it's not, taken like I have favoritism or whatever that is. But I really feel like we miss a lot of opportunities to do the best part of our job and advocate for our clients by sort of adhering to some of those rules that we have all learned about sharing less information or not being as descriptive. So I think many people probably have been in the same situation that you are, kind of erring on caution. And I look at a lot of that as sort of a missed opportunity. Okay, so we're not going to read a study. I'm going to briefly tell you about it, really briefly. And the purpose of that is so that we can talk about what you believe, what role you would take, how involved you would get systemically in this case, or where you believe, maybe there was a crossover. Maybe you believe that that's uncomfortable to me. That's not what I would have done. And so, obviously this was a case that I worked on, and this was a very sort of near and dear case to me. And the reason for that is this case was such a good example of how important a working system is. So this child was orphaned ultimately and had no parent to speak for them. And there was no identified guardian at the time. So the court was sort of scrambling to identify a guardian and obviously wanted to do what was in the child's best interest. There was a lot of sort of things that were not complete. So the court really just had to sort of punt and figure out what to do. And in this case, the system was so good about working together, collaborating, communicating. There was such respect for every role within the system. And I really feel that that is what allowed this child to do and get the best plan that he could have. And so this was great to me. It was great evidence of how important that is. And so I guess let me just quickly read it because I'll leave out information if I don't. Like I said, I don't like to be misunderstood. A 3-year-old boy, Shane, has delayed development, very poor fine motor skills, a flat head, and hoards food. He can be aggressive and have infantile behaviors. In therapy, he mimics infantile behaviors such as discovering his hands, playing peekaboo, tracing his hand outlines, etc. Currently, Shane tantrums at drop-off times at school, at nap, and when other children in his class come and go. He is currently placed with his maternal great aunt and his uncle, and his mother is in and out of the psychiatric treatment center, and his father committed suicide while Shane was at home. His great aunt and uncle appear committed to his well-being and are open to services. Previous to Shane's mother being in the psych hospital, she was living in the aunt and uncle's finished basement apartment. They are in their late 60s. The great uncle and great aunt work outside of the home and care for the elderly parents. The great aunt and Shane's mother have a positive relationship. Shane's mother admits to experiencing early childhood trauma and neglect. She explains that her parents used and sold drugs throughout her childhood. She explains that she and Shane's father were high school sweethearts and got married. When Shane was 2.5, Shane's father caught her cheating on him. He then committed suicide while he was caring for Shane in the home. She explains that since her husband's suicide, she has been depressed and filled with shame and guilt. It is reported that she has been more neglectful of Shane and has attempted suicide several times. She is a trained RN, but is not working at this time. She voluntarily placed Shane with her maternal aunt after DHS got involved. It has been noted that Shane exhibits symptoms of neglect. Mom admits that he was neglected and she does not know how to care for him. Due to Shane's behavioral struggles like separation anxiety, DHS suggested that Shane begin therapy. When Shane first began therapy, he was taken to a community mental health center and met with a therapist who was not trained in play therapy. In the first several therapy sessions, Shane reportedly used the dollhouse and repeated themes of the mother doll thrashing around inside the house, bumping into walls, and lying in bed. The therapist identified that Shane was too young to be in therapy, is not able to verbally express anything, and felt that therapy was not beneficial at this time. The therapist also suggested, when asked, that Shane not be told about his father's suicide, rather he be told that his father had just gone away for a while. The family also began working with a Be His worker. After discussion with the caretakers, DHS, and the Be His worker, the Be His worker suggested that Shane begin therapy with a new registered play therapist, as he is displaying early attachment trauma. Shane also had significant anxiety when separated from his caregivers. Shane began therapy with this therapist. This therapist spoke with the DHS worker and asked more about Shane's social history. The therapist explored more about mom's suicide attempts, and it was disclosed that on 2 occasions, mom admittedly attempted suicide. She had self-administered a significant amount of insulin and had seizures while in the home of her great aunt. On both occasions, Shane witnessed this, and the paramedics were called, and mom was placed in the hospital. I continued therapy with the play therapist and addressed neurosequential trauma through play therapy. DHS was working on reunification efforts. DHS had asked the therapist to assist in a therapeutically positive reintroduction of Shane to his mother, as she was now in a group home setting. In the past, visits had been sporadic, and Shane would often display significant behaviors before and after visits. The DHS worker recognized mom's ambivalence as well, but felt the need to persist with visits. It was of concern to this therapist that the inconsistency of mom, her ambivalence, Shane's security and attachment struggles, and the time frame from DHS was incohesive. This therapist was asked by DHS to begin family therapy. This therapist decided that before meeting with mom and Shane together and before visits should begin, the therapist wanted to meet with mom individually and offer psychoeducation to her regarding Shane's attachment and trauma needs and assess her ability to respond with insight and empathy. Therapist also continued to meet with Shane to strengthen his security and work on attachment. In the 4th session between mom and the therapist, mom continued to discuss with the therapist her concerns about not being able to give Shane what he needed and being fearful that he would have the same childhood she did. She shared that she feels undeserving of being a parent to Shane and feels solely responsible for her husband's death. Shane's mother continued to express fear that her mother and her in-laws want Shane, but that she does not trust them or their ability to raise him in a healthy way. Mom can share that she is still considering. After thoughtful consultation, this therapist and mom discussed giving herself permission to not parent Shane and explored how allowing her great aunt and uncle to parent Shane was a loving thing to do. Therapist and mom explored her attachment needs and her feelings of shame. Therapist and mom had built a very positive and trusting relationship, and mom identified that she finally felt heard. Through this time, therapist had not recommended that visits between mom and Shane resume, as mom was displaying instability and was not able to extend empathy to Shane. Days after the session with mom and therapist, DHS contacted therapist to report that mom had attempted suicide while in the group home. She was currently in a coma as she had injected herself with 100 vials of insulin. She was being moved to hospice and was not expected to live. Staffings were held to discuss how to proceed with helping Shane understand her death, how to best meet his needs, and how to proceed with court. The therapist went with Shane and his great aunt to hospice so that Shane could have closure. The therapist and the great aunt told Shane that mom was sick and would no longer live. Shane wanted to hug mom and asked that she rub his back. Great aunt assisted mom in doing so and encouraged Shane to hug her. The therapist offered support and reflection to Shane and great aunt, and then mom died 2 days later. When mom died, maternal and paternal grandparents put in a request to exercise their grandparent rights and have custody of Shane. Mom had not completed her will, and Shane was now deemed an orphan. According to the law, both grandparents had good cause to assume custody of Shane. Mom had made it known to DHS, this therapist, and her lawyer that she did not want that. So when you think of all of the parts to this story, there's a lot of systems in place, right? There's the family system, there's the court system, internally there's DHS, all of the things happening. What I would like you guys to just sort of think about and talk about is how involved would you have gotten? Do you feel like, what's your opinion? What do you feel like was within the lane of the therapist? How do you feel like you would advocate for Shane? How do you not give placement suggestions? Any of like the ethical or systemic kind of contradictions or confusions that show up in this case?
I'm wondering if the same therapist who is working with Shane is the therapist that was working with mom. Am I understanding that correctly? Okay.
And so I'll, full disclosure, obviously, I was the therapist, right? And so that mom had her own individual therapist while she was in the treatment center. But when I was asked to start family therapy, the way I started it was just working with mom first. So that's how that role was.
I think one of the contradictions that comes to my mind is the idea that the mother supposedly does not want these people to be responsible for her son. Was I reading that right? And that okay.
Right. She didn't want any of the grandparents to have her son. But she chose to put her son with her great aunt and uncle.
Okay.
But that wasn't legally documented, right, Kate? Is that what we're understanding?
Right.
Honestly, I would read this case and be like, I don't know if I can take it on. I mean, there's so much. So blessed that you took this on. But I feel very drawn to the fact that this little boy needs an advocate desperately. So you would want to help, but I would have to have such strict boundaries of how me personally would not get sucked into that case, because my heart bleeds for the little one. As you're reading it, I felt so many different emotions come up. I thought, ooh, I would have to do a lot of work on me to be able to take on a case that difficult. But I'm not in a clinical setting, so I don't end up having cases like that. And but I do feel that there is an ethical obligation that you would want to absolutely help. So how do you advocate for Shane? I think going back to everything you've said and stating facts, but also how do you balance that with honoring the mother's desires? That's tricky. I would definitely consult other therapists.
As well as other professionals, right? Like listening to you, Trisha, like, does Shane have a guardian ad litem, right? Like, can we get somebody on his team to do some of the pieces that are outside of our lane, so that, like Kate's been talking about throughout this whole training, right? Like, we're in our lane, we're doing what we can, but helping, a child at that have the support so that others can do the work that they are supposed to be doing.
That's what I was thinking of also is utilizing other providers. My agency, we have a program that specializes in foster and adoptive care. So they strictly work with kids who are either in foster care placement, kinship, or fictive kin, or are adopted. And so on that care team, I was a part of that for a while, where I was the therapist, but then we also had a permanency support specialist. And so they are not a clinical therapist, but they are, they have, again, their own specialized trainings and all that kind of stuff to be in their lane. And so we regularly worked together and staffed the families that we had of how can the permanency support specialist work with the parents or the guardians or both, whatever the placement may be, and kind of combining that with the clinical aspect. And what does that look like when we work with the DHS worker and the guardian ad litem? And so really having that team approach, not only with the external systems, but within our own internal system was huge. And it helped, like the clinical work that I was doing as well, to make sure that I was, in my lane and having the right opinions, and that we could both advocate in that way for the kid or the parent, and having that own role. Like I was primarily for the kid, they were primarily for the parent type of thing. So I think having a team approach would be huge in a more complex case like this.
One thing, that I recall right from the beginning is the DHS worker is somebody that I'd worked with in the past and really, trusted and knew. I knew her approach to things and sort of like her, her trends, I guess I would say. And I understood that her role was she needed to look at restarting family visits and all of that. And you know, as a therapist, there is sort of that pressure sometimes, right, to align with DHS and to kind of do what they have to do. Or there's sort of that feeling of like you're angry at them because they're not doing what you want them to do. And it was really important and it was really valuable that she and I could both respect each other's roles very clearly. So I could respect the fact that they needed to start some sort of family movement. So starting family therapy, but I could choose clinically how I felt that that would be best designed. And meeting with a parent is something that I typically would do anyways as a way to start to gauge where they're at. And so I allowed myself, right, the control or the structure that I needed to put in place to make that decision while leaning in and working within the system. You know, I could have said, nope, I'm not supportive of family therapy. I'm not going to do it. All that would have done was had them look elsewhere for another family therapist. And maybe that would have been okay, but I felt that there was a way that I could do it that felt right to me, or that felt like it was aligned with what I felt clinically was necessary. And same with visits. You know, she was able to say, clinically, you can support why we're not starting visits yet. Then the court will respect that because that's your clinical drive. As a DHS worker, she can't say that. And so recognizing that we have to work together in that so that what this child needs can be supported legally and through court without coming back to hurt him in the long run. Had the DHS worker just said, well, we're going to start visits or we're not going to start visits, but had no sort of clinical reason to not doing it. And so I had to sort of take the responsibility or take the fall in a sense, or be able to defend why clinically that was not supported by me at this time.
Kate, we did have a question in the chat that asks, I'm curious why the letter doesn't mention that the therapist was aware of the mother's request or desire to have the child stay with the great aunt and uncle.
So I think that's a really great question. And to be honest with you, it was tricky for me to know how much of what mom and I talked about would be relevant to, or would be necessary to my role in that moment, right? The thing is, I wasn't the only person who mom had shared that with. And so I did not feel like I needed to kind of bring that piece into being my role when there was, you know, 2 other people within the system that also knew that. Again, I can't give placement suggestions. I can't be specific. And I felt that if I started to go down that path, like, well, mom even told me that, I feel like that would start bordering on preference of placement.
I also kind of noticed that there's no like opinions or whatnot as far as like who wants what, because I imagine like the grandparents, aunts, uncles, everyone probably has their own opinion of what they think is best. I was wondering if there would ever be like situations where you would include like, you know, the child has expressed to me that they would rather live with so and so, like assuming that they could.
I would if I did not feel that that could be hurtful to relationships.
Mm.
And at that child's age, I mean, you and I as therapists know that there's credibility in that. However, that I don't think that child would be able to defend that opinion or should have to defend that opinion. And so I didn't think it would be appropriate to say that. That child had so much disruption in his attachment that he couldn't even comprehend what that meant.
No, thank you. That makes sense because, yeah, like you said, if you start throwing that in, then people might ask them like, well, why do you want to live with so and so? And that would just be more stressful.
Mm-hmm. Mm-hmm.
I've been recommended before to kind of use a blanket statement of like, I'm not a custody counselor, so I cannot make that recommendation. What are your thoughts on that statement? Like, would that be a good statement to use, or should it be worded or done differently?
I think something like that is important. Again, like that just defines what your role is. But I would also offer, you know, I'm not somebody who can give a placement or custody suggestion, but I can speak to what a child with his diagnosis or with what his needs would benefit from when it comes to what kind of family he should live with. So I can talk about, like I did in the letter, right? the stability, the security, somebody who has education and attachment. I could point out all of those things. And really then the court, the DHS worker, whoever's making that placement ruling, then has to look at like, oh, well, the great aunt and uncle have exhibited these things. And I've pointed that out in my letter. I can't say if the grandparents are able to love it because I haven't worked with them, but somebody else could determine that. And along with that, regardless of who he lives with, if that doesn't work out, then if they have to move him to a new home, that will help them select a new home for him. Being able to like sort of predict or look at the beginning, is this family willing to get education? Is this family, able to meet his needs? So that hopefully his attachment struggles aren't going to be perpetuated or grow because of all of the stuff going on. Did anybody feel there was anything in the case study that felt really uncomfortable or felt like, ooh, that does not feel ethically okay or professionally okay, or I would not have done that?
For me, it did not, but I can see the part about going to the hospice, the therapist joining the family out of the traditional office setting. I think that would be worth speaking to a little bit.
Sure.
I'm not uncomfortable with that, but I know many would be.
Sure.
Something that popped out to me was that note about how the previous therapist recommended the client be told their father had gone away for a while. I can understand not explaining everything to a 3-year-old given the circumstances, but just that in particular rubbed me the wrong way.
Mm-hmm. So I think I would agree with you, Mike, about I don't think that was ethically or clinically helpful to the child to say it that way. So I would agree with you on that. I think regarding the going to hospice, 100% that would be a personal decision. And it would be something that you'd have to run past your supervisor or sort of go through that consultation process with. Obviously, it's not something that I could bill for because it was out of the office. And so then you have that whole dynamic too of like, what is your ethical responsibility regarding billing and all of that. And I took the risk and went. So it never, came back to bite me. Nothing negative came out of it. For sure, there would be some discretion about that. And there could have been some sort of action taken, maybe. I did feel when I went through my own ethical decision-making process about that, I did feel my role could not be to sort of like be the person supporting him at hospice or making decisions or any of that. But because the aunt was there and the aunt was so ready and willing to be that support person, I felt like it was a really great opportunity to model and to coach her through how to work on attachment. So I felt from a clinical perspective, I could support my reason for using that as an opportunity. And so, there was definitely some ethical decision-making process that had to go into that.
Well, I'm thinking of situations where I've heard therapists go out into the environment with folks for like desensitization. I'm originally from Minnesota, and the 35 bridge that fell down, I remember in a training, a therapist went to the bridge with the client. So I wanted to throw that out there.
Mm-hmm. Mm-hmm.
Kate, maybe you've shared, and maybe you can't share. So, but who had legal guardianship of the client at the time of mom's passing? And I only ask,
I believe it was the state.
I only ask because I would be curious, like in a situation like that, if a therapist was able to obtain kind of consent from the guardian to be seen in, in an offsetting situation. And I wasn't sure if that was kind of part of that process or something that other providers could be aware of if a situation.
I think it was tricky. I'm thinking back to it because mom had not died. Custody could not be given to anybody else, but The state had guardianship. Even the great aunt and uncle, like the same rights mom had to sign permission for things. So it was a really sort of like, nothing was in stone at that point because it was so fast. Okay, so I'm looking at the time. Let me just kind of point out some of the outcomes of that case, and then we're going to navigate how to manage the rest of the presentation. Some of the things I like to kind of point out and reflect back to the guideposts that we talked about. So the therapist was asked to be in court, right? The therapist didn't choose to go to court. The therapist was asked by the team. And so that's one important part to point out when it comes to when we talked about identifying who asked you to write the letter, identifying who asked you for participation. The therapist was asked to be there. The judge had asked the therapist to identify the needs, the attachment needs. And the reason I point that out is because it indicates that the judge recognized there was an expert, right? The judge could have just followed the book and gone through whatever legal proceedings they had to go through to make those decisions. But the judge sort of paused and said, you know what, we have somebody who can speak to something that none of us in this room really can speak to. And I think that is a really encouraging sign. And it reminds us that it's really valuable if we are able to do that. It's really valuable to use our voice in the system. As a therapist, I listed the treatment course and the progress. I referred to my expertise on attachment, trauma, and stability. I did not speak for mom or share mom's words or thoughts. And I did not identify a favored placement. I did share reflections on how Shane and his great aunt and uncle had made significant progress in their attachment. And I could say that because of me seeing it. So it was based on what I saw. The judge identified that the play therapist was in a role to be unbiased and to be Shane's voice and had comprehensive knowledge. So the judge helped kind of identify the role and say, here's what I want sort of your role to be. And it felt very aligned with what clinically was appropriate. The therapist did not need to know what the laws were about placement, custody, or even being an orphan. It was not relevant for my role. I could have gotten overly involved in that or felt I needed to know, but I think that would have maybe offered opportunities then to speak to things that were not within my lane. The system deflected to the expert, and the expert shared facts, observations on information that no one else had or was able to share unbiasedly. So there's so much value in that, and the system was able to see that. Shane's well-being was taken into account, and the laws are not written to protect children, they're written to protect families. So, the grandparents having their rights or that kind of thing, or even the attachment needs, right? Speed up visits, start visits with this family. Most of the people in the system would have done what the law is telling them to do, but that might not have been clinically what this child needed regarding what I was the expert in. Anything about that?
Okay, I think it's kind of confusing, like being considered a family therapist, but prioritizing the child, I guess, because it seemed like mom had a lot of work to do on herself. And then after the therapist and the mom discussed allowing herself to let the great aunt uncle take care of the child, things seem to like get worse for mom. And so my curiosity is around like, how do you not let countertransference of like what you want for the child get involved in like what's best for the mom?
I think this is like Pandora's box, and so I'm not going to be able to speak to all of it.
Yeah.
But without saying it, but I can say it now, right? Mom was asking for permission to kill herself, right? That's what she was wanting to do. And I knew that I can't stop that, right?
Yeah.
So my role, what was in my lane, was to best advocate for my client's needs.
Mm-hmm.
It would have been, in my opinion, it would have been negligent of me to continue to push mom to care for him.
Mm-hmm.
Not that I wanted mom to kill herself, obviously. Not that I was saying, yep, go for it.
Of course
But I
not.
had to
Yeah.
be realistic, right? I had to look at it like,
Yeah.
she's trying to do something. She's trying to have some power here. She's trying
Mm-hmm.
to be an empowered parent and say, listen, I know I'm not going to live. So
Mm-hmm.
help me get my child what he needs. And
Mm-hmm.
so that can be a really slippery slope, and it can be scary. And I'll tell you, when all of this happened, I felt very like haunted by that. Like, I knew this was going to happen. I didn't stop
Feel
it.
it. Yeah.
But I believe that it would have happened regardless. Believe that it was an
Mm-hmm.
opportunity to really pay attention to what's within my control and what's not, and how can I use it for good.
Yeah.
Forcing mom to do it is not going to be in the best interest of anybody. And so,
Mm-hmm.
um, but for sure, I mean, that was very tricky, and how to sort of like not say what you know is happening, or how to navigate through that ethically, and just consciously, just knowing what is
Yeah.
actually happening.
Mm-hmm. Yeah.
So what I want to do with the short time that we have left is, I guess what I would encourage is, maybe, and Colleen, maybe I'm being really premature here, but maybe we can talk about doing like part 2 of this training if anybody's interested in, so we don't have to like just slide through. Okay.
Absolutely, Kate. That would be incredible. We can get that scheduled as soon as you want on your time frame. So
Great.
yes, I'm all for a part 2.
So let's make that an option. And we will, I'm sure, reach out about when that can be. And but a quick summary moving forward, the other things that we would be talking about, or that we have to consider working within the system, is what are assessments? What assessments can we do? How do we provide them? How are they beneficial? And again, I'm not going to go into all of it. And I would share some information about those assessments and how things kind of come up, how we word assessments. Because the truth is, as therapists, we're doing assessments all of the time, right? Sometimes we think because we're not doing standardized testing that they're not assessments, but an assessment can be anything if we call it an assessment. And if we explain how we do it, what information we're taking. We talk a lot about how to make appropriate recommendations and assessments. We talk more about testifying, a little bit more than we already have. What to do before court, how to know your role, tricks to testifying, and kind of going through that with a fine-tooth comb. And then speaking a little bit about the Court of Appeals, and how the reason I bring this up is because, as an expert witness, the Court of Appeals is often involved in challenging whatever side brought in the expert witness to come. So often it's like somebody out here is trying to discredit me for the sake of appealing the outcome, not necessarily because what I said was inaccurate, but to sort of discredit or to show that there's a fault in what happened. And so at one of the expert cases that I did was a blind witness on, there was a Court of Appeals. And the reason I bring it up is so that we can point out how, when it went to the Court of Appeals, the response from the Court of Appeals supported all of the things that we learned in the first couple slides about, as long as we do these things, as long as we stay by our guideposts and stay within our lane and speak about what we're being asked to speak about and all of those things, it will uphold and it will sort of give more credibility and support you more in a system or within the court. And there's a great example of how that kind of went through all of the channels that could try to discredit it. And all of those channels supported the guideposts that we talked about. That those are all the things that a therapist needs to do in order to stay credible and in order to stay valid within their testimony. So again, if we do sort of a part 2, we'll get into all of this, but in summary, I can't stress enough how much I hope that you continue to grow your confidence and you continue to believe that you are the expert in this, so that you can really see how much great change and how much impact you can have, not only for your clients, but as a community and as a profession, and with all of these other professionals that we work with. How great would it be if laws started to be written based on some of the knowledge and experience that we have as therapists, right? So we sort of have to make that place for ourselves so that other people within the system also make that space. So that's my 2 cents. Along with that, if anybody is ever in need of sort of consultation specific to a case regarding systemic work or court work, I do that as well. If it's just like, even a couple sessions here and there, just to help write a letter or just to help navigate something, you can always contact me for that as well. So, but we will schedule a part 2. So if anybody has any quick questions or comments, I think we have a few minutes for those.
Right. As you are thinking of them or getting brave enough to, Mike, did you have one? I don't want to cut anybody off.
Oh, no, you're fine. I was just going to say, I appreciate you really hammering in that thing about confidence, because especially I myself am a bit newer in this type of position. So it's really hard for me to think of myself like as the expert, but I like all the tips and tricks you gave as like far as how to take the things that you're seeing and observing and, make them factual.
Yeah.
Right. To find your expertise sort of within yourself, like where are you confident to say you're an expert?
Yeah.
Mm-hmm.
Yeah. We cannot thank you enough, Kate. I did put the evaluation and the CE quiz in the chat box. So please make sure that you guys are clicking that link for the CE quiz so you get your live webinar credits. Take the time to fill out those evaluations. I put Kate's website in the chat box again as well. She has some incredible resources on that website. I know one of you earlier mentioned she should write a book. She does have guides both for parents and professionals, so some guidebooks available for purchase on her website. Kate does parenting classes. She has a parenting class starting next week. Is that virtual or is that live in person?
It's either virtual or in person.
Okay. Mm-hmm. So, and then an attachment parenting class in April. She has an incredible training coming up on May 10th about how to teach attachment parenting to parents. I'm excited. She's speaking at the Iowa Play Therapy Spring Conference in April 12th. Right. Am I right? Mm-hmm. April 12th in Dubuque. So lots of other opportunities to absorb Kate's knowledge and information. Please be sure to check those out, and we will absolutely work on getting part 2 scheduled. I've already emailed our training coordinator. So for those of you that are in this training, I believe there's a spot on the evaluation to get added to our training mailing list. Go ahead, and if you would like to do that so that we can email you right away about when part 2 is scheduled, and make sure that we connect with all of you to let you know that that is available. So thank you so much.
Thank you.
Thank you for joining in on today's training. We look forward to having you join us again. Heart & Solutions is proud to provide CE-eligible trainings for our counseling community. This training may be eligible for continuing education credit hours through either the National Board for Certified Counselors, provider number 7376, or the Association of Play Therapy, provider number 21-645. To obtain CE hours for today's training, be sure to follow the steps in the description below.